The HOA said my house color was too joyful, so I took them to court and changed the entire neighborhood. Would you have fought back or just repainted? When I first bought my home in the Oak Ridge Estates neighborhood, I imagined a peaceful suburban life. A garden in the front yard, barbecues with neighbors, a little white picket fence. What I didn't imagine was being dragged into a months-long feud with the Homeowners Association, especially not over paint. I'm Thomas Carter. I work remotely as a graphic designer, and one of the things I've always loved is color. I see the world in palettes, warm hues, cool contrasts, vivid splashes of expression. So, when I moved into my new home, I wanted to give it a personality. Not wild, not eccentric, just cheerful. After doing my research and checking the HOA handbook twice, I settled on a warm, peachy yellow for the exterior. Not neon, not garish, just soft, inviting, and, yes, joyful. I even ran the color past the paint consultant at the home improvement store, who said it was one of their best-selling tones for Mediterranean-style homes. I painted the house over the course of 3 weekends. Friends came over to help. Neighbors waved. No one said a word at first. Then came her, Margaret Lyles, HOA president, late 60s, sharp as a thorn bush, and about as welcoming. The first time I met her, she was on my lawn, arms crossed, lips pursed like she'd just smelled expired milk. She didn't bother knocking on the door, she just called out like she was commanding a dog. Mr. Carter. What is that? I stepped outside, paint roller still in hand. Hi. Just wrapping up. You mean the color? Yes, the color, she spat, as though I'd painted the house in radioactive slime. It's too joyful. At first, I laughed. I thought she was joking. She wasn't. Margaret informed me that the HOA had standards, and this color, Sunshine Marmalade, as it was called, was not in harmony with the neighborhood aesthetic. I politely disagreed and pointed out that the HOA handbook only prohibited excessively bright, neon, or distracting colors, none of which applied. She narrowed her eyes and said flatly, "The board will review it." And boy did they. 2 weeks later, I got an official letter from the Oak Ridge HOA citing me for a decorative violation, claiming my house color did not align with the neighborhood's natural and muted tone values. The letter demanded I repaint my house within 30 days, or face daily fines of $250. At this point, I was annoyed, but still hopeful. Surely, this could be resolved. I drafted a polite response, attaching side-by-side photos of other homes on the block. Some beige, some with light blue or olive green accents, not exactly muted in all cases. I also cited the handbook. A few days later, I received a notice. My appeal was denied. No explanation. No meeting. Just denied. Things escalated quickly. Fines started arriving. Margaret took to walking past my house with a clipboard, photographing it like I was running a meth lab instead of sporting a happy paint job. Some neighbors even told me she'd warned them I was lowering property values. But others? They quietly voiced support. A few even admitted they liked the color. Makes the street feel less dreary, one neighbor said under their breath. Still, the board wouldn't budge. Margaret upped the pressure. I received a notice that unless I complied, a lien would be placed on my property. That got my attention. I couldn't believe a simple paint job could lead to legal threats over aesthetic interpretation. So, I did what any reasonable person would do. I lawyered up. Enter Rachel Martinez, HOA litigation expert. She'd seen cases like this before. And she wasn't impressed with Oak Ridge's antics. This isn't about the paint, she said during our first meeting. It's about control. Rachel reviewed the HOA's guidelines and concluded that their argument was vague at best, and arbitrary at worst. The phrase, not in harmony, was too subjective to enforce consistently, especially when no specific palette or pre-approved color chart had been published. So they're enforcing a personal opinion? Exactly. We sent a formal cease and desist to the HOA, demanding they stop issuing fines until an unbiased review could be conducted. They refused. In fact, Margaret seemed emboldened. She called a special emergency meeting of the board, which was attended only by her and 2 longtime allies. They voted to double the fines. Now I was being charged $500 a day. Rachel smiled when she saw the letter. They just handed us a case. See, in HOA law, there's a little thing called reasonable enforcement. Boards can't impose penalties that are punitive or arbitrary. By doubling the fines without following a transparent process, they'd stepped out of bounds. Rachel recommended we file for injunctive relief in civil court to stop the fines, challenge the lien threat, and ask the court to review the enforcement validity. The moment the HOA received the lawsuit, everything shifted. First came the panicked emails from their lawyer, offering to revisit the matter. Then came the desperate offer. If I'd repaint the house a more earth tone adjacent color, they'd waive the fines. But I was done negotiating with bullies. No deal, I said. See you in court. What started as a simple paint project had turned into a battle of principle. I wasn't just fighting for myself anymore, I was fighting for every homeowner who'd ever been pushed around by an HOA president on a power trip. And I was ready to win. Court dates have a way of making even the most confident person nervous. But as I stood outside the county courthouse, tie slightly crooked, files in hand, and Rachel by my side, I felt strangely calm. Not because I was certain we'd win, but because I knew we were right. The case had drawn more attention than I expected. Turns out, people love a good HOA drama. By the time we walked into the courtroom, there were a dozen Oak Ridge residents in the gallery. Some curious, some supportive, and a few clearly there on Margaret's behalf, looking down their noses like I'd vandalized the community. Rachel handled opening arguments. She laid everything out with surgical precision. The vague language of the HOA handbook, the absence of an approved pallet, the selective enforcement, and the excessive fines issued without due process. The HOA is not above the law, she told the judge. They must follow fair and consistent procedures. My client's choice of house color may not please everyone, but it is not in violation of any specific, clearly defined rule. Margaret's side, on the other hand, tried to lean into emotional appeals. Their attorney, a stiff, gray-suited man who looked like he hadn't smiled since 1992, argued that I had upset the uniform harmony of the neighborhood and was eroding community values. The judge, a middle-aged woman with sharp glasses and a sharper gaze, raised an eyebrow. Can you point to the specific provision that Mr. Carter violated? Well, Your Honor, it's a matter of interpretation. So, no explicit color list? No visual standard? Not as such. Rachel jumped in. They're trying to penalize my client based on personal taste, not policy. Over the next few hours we called witnesses. First up, Mr. Jennings, a neighbor 2 houses down. I think the house looks nice, he said plainly. Brighter than most, sure. But not offensive. It doesn't bother me. Then came Amanda, who lived across the street. I actually painted my shutters teal 2 years ago, she said. No one complained. Margaret even complimented them at the time. We presented photo evidence showing multiple homes with bold accent colors, none of which had received violation notices. The hypocrisy was glaring. Margaret took the stand herself. She was composed at first, articulate, controlled. But Rachel was ready. Mrs. Lyles, can you explain how you determine whether a house color is in violation? Well, we use our judgment. The board reviews. Is there a vote? Are residents allowed to attend? It's handled internally. We know what fits. Rachel stepped closer. Do you have any formal training in color theory? Design? Architecture? No, but... So this is all subjective? It's experience-based. I've lived in Oak Ridge for 27 years. Rachel paused for effect. And during those 27 years, how many times have you issued fines for exterior paint? Margaret hesitated. 3, maybe 4 times. We presented evidence that one of those cases had also involved a newer resident who had disagreed with her over a landscaping proposal. There was a pattern forming. Margaret wasn't just enforcing rules, she was enforcing loyalty. The judge leaned forward. Mrs. Lyles, this sounds less like policy and more like personal enforcement. That's a problem. For the first time, Margaret looked rattled. After court adjourned for the day, I stepped outside to a surprise. 2 more neighbors had shown up with coffee and quiet cheers. One whispered, "You're doing what we've all wanted to do for years." Apparently, I wasn't alone in my frustrations. Back home, I found a flyer in my mailbox, unsigned, but clearly from someone on Margaret's side. It warned neighbors that I was trying to destroy the neighborhood culture and waging a war against order. Order? Over a warm yellow hue? Rachel advised me to document everything. If they keep targeting you, it strengthens our case for harassment and retaliation. 2 days later, things got more interesting. An anonymous tip landed in Rachel's inbox. Scanned pages of what appeared to be Margaret's personal notes from private HOA meetings, notes that weren't part of the official record. Scribbled at the top of one page were the words, "Carter must be pressured, paint sets bad precedent." That was our smoking gun. Rachel filed a supplemental motion to include the notes as evidence. Margaret's team objected furiously, but the judge allowed it. It showed intent, proof that the paint wasn't the issue. Control was. Then came the unexpected. An older couple from the board resigned, quietly, respectfully. One even sent me a message thanking me for doing what's right. The board was fracturing. Margaret was losing her grip. A week later, we returned to court for the final hearing. Rachel gave her closing statement. This case is not about color. It's about fairness, about an individual being targeted by a board that operates in shadows, punishing those who don't conform, not to policy but to preference. The judge took her time. And then, the ruling came. She found in our favor. The fines were deemed unenforceable. The lien threat? Nullified. The HOA was ordered to revise its guidelines to include clear, objective criteria. And, this was the best part, they were barred from taking retaliatory action against me or any resident based on vague or unwritten standards. The courtroom murmured. Margaret looked like she'd swallowed a lemon. But I wasn't angry. I was relieved. Because this wasn't just a win for me, it was a message to every overreaching HOA board out there. You don't get to weaponize taste. As we left the courthouse, Rachel grinned. Told you it wasn't about paint. She was right. And I had one more thing planned. The first morning after the verdict, I stepped outside with a cup of coffee, took in the golden glow of my freshly painted home, and breathed a sigh of freedom. No clipboard clicks, no passive-aggressive note, no threats about liens. For the first time in months, it felt like my house again. But the story wasn't over. The ruling had sent ripples through Oak Ridge Estates. Within days, Rachel started receiving calls from other residents asking about their own run-ins with the HOA, a garden gate 2 inches too tall, a lawn gnome in violation, a holiday wreath removed for being too flamboyant. Turns out, Margaret's selective enforcement stretched a lot farther than my house color. That quiet frustration? It had been simmering for years. So, I decided to do something with my newfound clarity and credibility. I wrote an open letter to the community, not angry, not gloating, just honest. I detailed my experience with the HOA, the court's findings, and encouraged residents to attend the upcoming board meeting to discuss reform. I didn't expect much. But when the day arrived, the community center was packed. Standing room only. Residents who never showed up to anything came in person, armed with questions, statements, and, in some cases, outrage. Margaret, still technically HOA president, opened the meeting with her usual stiff posture. But this time, there was no power in it. Her voice wavered. The room wasn't hers anymore. A young couple spoke first, sharing how they were fined for installing solar panels, despite no written rule against them. An older gentleman recounted how his wife's flower pots were deemed non-compliant because they didn't match the HOA's vision of uniformity. Then someone brought up the scan notes we'd submitted to the court. The room gasped. Margaret tried to deny their context, but it was too late. The trust was broken. One brave soul stood and said what everyone else was thinking: we need a new board. It wasn't mutiny. It was democracy. A petition began circulating that night. Within a week, it had more than enough signatures to trigger a recall vote. Margaret fought it, claimed it was a dangerous step toward chaos. But the community had seen what order under her looked like. 3 weeks later, the vote was held. Margaret was removed. So were her closest allies. In their place, the community elected a mix of new faces, diverse, inclusive, and most importantly, open to reform. And guess who they asked to join the committee that would revise the HOA handbook? Me. At first, I hesitated. I never wanted power, just fairness. But I realized that stepping up was the only way to ensure no one else would be bullied into repainting their home, ripping up their garden, or hiding their personality to appease outdated sensibilities. So, I joined. We got to work immediately. We created a clear, visual-approved palette but left space for custom colors with a transparent review process. We published all meeting notes and open decisions to community feedback. We even added a clause about decor being judged by safety and structure, not subjective taste. And the best part? The new board made it official policy that homeowners could appeal any decision at a public meeting, with no fear of retaliation. That was Rachel's suggestion, and we named it the Carter Clause, half-jokingly. But it stuck. As the months passed, Oak Ridge changed. More houses started showing personality. Not in a chaotic way, but in a colorful, lived-in, real way. One home got a pale lavender trim. Another added a deep forest green door. A family at the end of the street painted their mailbox like a sunflower, and nobody batted an eye. The joy that Margaret had once feared? It bloomed everywhere. And she? Well, Margaret still lives in Oak Ridge. She keeps to herself these days. Occasionally, we pass each other on walk. She doesn't smile, but she doesn't glare either. I think somewhere inside, she realizes this was inevitable. HOAs aren't evil. They're meant to serve, not control. But when people mistake authority for ownership, when leadership becomes dictatorship, it's up to the community to correct course. I didn't set out to be an activist. I just wanted to paint my house. But sometimes, the smallest stroke of color can start a revolution. So, if your HOA ever tells you your house is too joyful, remember this: rules are supposed to protect, not suppress. And sometimes, standing up for a little paint is really about standing up for yourself. Thanks for watching, and remember, a neighborhood isn't built on conformity. It's built on community. Don't forget to like, subscribe, and share if you believe every home deserves to shine, in any color.